CBS News legal analyst Rikki Klieman is with us, and she watched the Barr hearing in its entirety yesterday. And as you heard, she's got it. Yeah. Good morning, Rikki. All right, so much to get through, so let's tick through this quickly, and nobody's better at that than you. First, Congress. What if they hold the Attorney General in contempt of Congress? What would that look like?
Well, what has to happen in order to hold anyone in contempt of Congress is you subpoena that person, the person refuses. Then at that point, you have to have a vote in Congress in order to hold them in contempt. Then at that point, if it is still refused, how do you enforce it? So you can have a fine, of course, but you would have to go to court in order to get an order to literally arrest someone and bring them in. We're really in uncharted territory.
All right, let's get to that hearing. Critics say that the Attorney General of the United States looked more like the president's defense lawyer than the Attorney General and chief law enforcement official. Is he supposed to be more independent?
He is supposed to be totally independent and impartial. You have to remember that the Department of Justice, although it is part of the executive branch, it is supposed to be the arbiter of fairness. What we heard a great deal of, not only yesterday, but in his statements and written statements before, is he worked as an apologist for the president about the president's frustration and his feeling about an inability to govern as a result of being, quote unquote, falsely accused. What William Barr winds up saying during the course of testimony is that any president, not just this president, if he or she believes they are being falsely accused, they have the right to get rid of that accuser. That is a very dangerous precedent indeed.
Did Barr's testimony yesterday really make the case more than ever that we need to hear from Robert Mueller?
There is no doubt that if we didn't think we needed to hear from Robert Mueller before yesterday, by the end of yesterday, we certainly know we do. And it is for good reason. William Barr is abundantly clear, which I think is very disturbing, that he and Rod Rosenstein came to a conclusion about approximately 10 episodes of obstruction of justice or potential obstruction of justice using a standard in a criminal case of proof beyond a reasonable doubt. He says in his testimony that he doesn't know why Robert Mueller came to a conclusion, which I call it a conclusion of equipoise. There is evidence about obstruction, but yet there isn't evidence about obstruction enough to convict in a criminal case. So who has the primary evidence? Robert Mueller.
But he left it in Barr's lap, and so Barr, having had it left in his lap, made the call.
Well, it certainly could be said that Robert Mueller intended, perhaps, to leave it in Congress's lap. Don't you think that Congress has the right to ask that question?
Well, it asks it of itself. It doesn't have to ask. The special counsel's handed it all off. Why does he have to?
Because we don't know, and Congress doesn't know. When he looked at approximately 10 episodes with sub-episodes beneath them, Don McGahn, the legal counsel for the president, being the most egregious that we can lay our hands on,
right.
and find out why he came to that conclusion.
And then just quickly, you know, Senator Klobuchar in her testimony tried to make the case that what she learned in law school was that you look at the totality of the evidence and a pattern here. Right. Doesn't that matter with those 10 instances of potential obstruction of justice?
I thought Amy Klobuchar gets an A+ because she had a goal in her questions and she got to it. She talked about lingering, those pardons, putting them out there, and acts of obstruction, and why doesn't the totality bring us to a different conclusion?
Really
it's the more we hear, the more questions we have.
Yes.
We're still not getting all the answers. Thank you very much, Rikki Klieman.